Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. Starting with the biggest update for today from the Supreme Court. You must be aware that last night, for the first time ever, a sitting Chief Minister of a state was arrested. Delhi Chief Minister Arvind Kejriwal was arrested by Enforcement Directorate hours after the Delhi High Court refused to grant protection to him from arrest. Kejriwal has skipped 9 ED summons in connection with the Delhi excise policy case, claiming that they were illegal. Seeking an urgent midnight hearing, Kejriwal filed a writ petition challenging the arrest before the Supreme Court. His counsel, Senior Advocate Abhishek Manu Singhvi, mentioned the matter before the Chief Justice of India this morning for urgent mentioning. The CJI told Singhvi that a bench had convened and asked Singhvi to mention the matter before the special bench. The CJI was referring to the special bench of Justices Sanjeev Khanna, M.M. Sonduresh and Bila Trivedi hearing the plea of BRS leader K. Kavitha against her arrest by the ED in the liquor policy case. By the time Singhvi reached the court, the special bench sitting had concluded and the regular bench of Justices Khanna and Dipankar Datta had assembled. When Singhvi mentioned the matter, Justice Khanna said that it would have to go before the 3-judge special bench which dealt with similar connected issues. Although a special bench was set to take up the plea later in the day, Senior Advocate Singhvi informed the court that Kejriwal had withdrawn from the Supreme Court his petition challenging arrest and that they would approach the court against the remand order. Later in the day, the Delhi Chief Minister was produced at the Rouse Avenue Court amid heavy security for hearing of ED's application for remand for 10 days of custody. During the hearing, Additional Solicitor General S.V. Raju informed the court that ED had complied with Section 19 of PMLA. He also contended that Kejriwal was the kingpin of Delhi excise scam. He was directly involved in the implementation of the policy and in the use of proceeds of crime. Senior Advocate Singhvi, appearing for Kejriwal, contended that before making an arrest, it was crucial to demonstrate the necessity for it. While the authority to arrest exists, it does not automatically imply that an arrest is necessary in every situation. He further said that yesterday it was argued in the Delhi High Court that Kejriwal was called in a personal capacity. However, today ED was providing material in the remand mentioning various aspects referring to the party as a company. The court reserved the order on the application. Stay tuned with us for the update regarding the remand. Also, adding to the troubles of Mr. Kejriwal, a PIL has been filed before the Delhi High Court seeking his removal from the post of Chief Minister of Delhi, saying that a Chief Minister accused of a financial scandal should not be permitted to continue in public office. Aam Aadmi Party ministers have been making statements in the media that Kejriwal will not resign from the post and if need be, he will run the government from inside the prison. The Delhi High Court today admitted the appeal moved by CBI challenging the acquittal of former Telecom Minister and current Lok Sabha MP A. Raja and various others in the 2G spectrum allocation scam case. The 2G spectrum scam was a major political and financial scandal which came to light in 2008. It involved the alleged undercharging by the government for mobile telephony licenses which were given to the telecom companies at throwaway prices. This caused a huge loss to the national exchequer. The licenses were issued by the Department of Telecommunications under the leadership of then Telecom Minister A. Raja. In 2017, a special court acquitted all the accused, including A. Raja and DMK MP Kanimoi, stating that the prosecution had failed to prove the charges. This verdict was later appealed by the CBI and the ED. It was CBI's case that there were glaring illegalities in the trial court order acquitting all the accused. Today, almost 6 years after CBI moved court challenging the order of acquittal, Justice Dinesh Kumar Sharma pronounced the order admitting the CBI's appeal. Coming to an update on the now scrapped Delhi liquor policy case. You know, last week, Bharat Rashtra Samiti leader K. Kavitha was arrested by the ED in this case. Today, the Supreme Court issued notice to ED on a writ petition filed by her challenging her arrest. A special bench of Justices Sanjeev Khanna, M.M. Saundaresh and Bela Trivedi, while hearing the petition, told senior advocate Kapil Sibal, who appeared for Kavita, that the bench was considering petitions to reconsider the Vijay Madan Lal Chaudhary judgment and Kavita's petition could be tagged with that batch. And that for bail, she would have to approach the trial court. Let me tell you, petitions seeking reconsideration of the Vijay Madan Lal judgment are posted in July. So if Kavita's petition is tagged with that batch, it would mean that her petition will come next only in July. When senior advocate Kapil Sibal requested the bench to decide the matter without asking them to approach the trial court, the bench made it clear that it would not let the statutory procedures bypass just because there was a political person involved. After the hearing was over, Sibal said, and I quote, "May I say something? I hope your lordships don't mind. History of this court will be written. This will not be a golden period." To this, Justice Khanna said, and I quote, "Let's see." The Delhi High Court has dismissed the pleas moved by the Indian National Congress against initiation of income tax reassessment proceedings against it for 3 years, that is 2014-15, 15-16 and 2016-17 by the tax authorities. A division bench comprising Justice Yashwant Verma and Justice Purushendra Kumar Kaurav pronounced the order today. Recently, the court had upheld the order passed by the Income Tax Appellate Tribunal on 8th March, refusing to stay a demand notice issued to the political party for recovery of outstanding of more than 100 crores for the assessment year 2018-19. Notably, Congress has also filed fresh pleas challenging initiation of tax reassessment proceedings against it for 4 different years. The petitions are yet to be listed before the High Court. In a significant ruling, the Lucknow bench of the Allahabad High Court has declared Uttar Pradesh Board of Madarsa Education Act 2004 as unconstitutional, violating the principle of secularism. While declaring the law as ultra-vires, the division bench comprising Justice Vivek Chaudhary and Justice Subhash Vidyarthi also directed the Uttar Pradesh government to frame a scheme so that the students presently studying in madrasas can be accommodated in the formal education system. This was in a writ petition challenging the wires of the UP Madarsa Board as well as objecting to the management of Madarsa by Minority Welfare Department, both by the Union of India and state government, and other connected issues. This ruling comes months after the state government decided to survey the Islamic education institutions in the state, and it had also formed an SIT to probe into Madarsa's funds from abroad. Also in 2019, the High Court has referred certain essential questions surrounding the concerns of the functioning and structure of the Madarsa Board to a larger bench. The Tamil Nadu Governor, Mr. R.N. Ravi, today informed the Supreme Court that he has duly invited MLA K. Ponmudi to swear in as the State Cabinet Minister. The Attorney General R. Venkataramani submitted to the bench led by CJI Chandrachud that the governor conveyed that he had least intent to disregard the court. Yesterday, as we informed you, the top court had expressed displeasure at the governor for refusing to re-induct Ponmudi as a minister. The CJI had warned of court intervention in case the governor did not act on the same. Due to reversal of his acquittal by the Madras High Court in the disproportionate assets case, Ponmudi was disqualified and had to resign as a minister. But last week, the Supreme Court had stayed his conviction. However, when Chief Minister M.K. Stalin recommended his appointment to the governor refused to re-induct Ponmudi by saying that it would be against constitutional morality. So the state had approached the Supreme Court. In another update, the Supreme Court today transferred to the Delhi High Court matters pending before different high courts across the country against the Information Technology, Intermediary Guidelines and Digital Media Ethics Code rules of 2021. The order was passed to enable a homologous hearing on the issues, considering that a large number of petitions were already pending before the Delhi High Court. The bench of Justices Rishikesh Roy and Prashant Kumar Mishra was dealing with a batch of pleas, some of which were transfer petitions filed by the Union of India and some were special leave petitions filed against interim orders of the High Courts, whereby certain provisions of the IT rules of 2021 were stayed. And one was a writ petition. While the petitions in the transfer cases were directed to be transferred to the Delhi High Court, the SLPs seeking modification of High Court's orders were disposed of with liberty to the union to make necessary prayer before the Delhi High Court. The petitions challenging the 2021 rules were preferred by digital news portals and social media intermediaries before various high courts. While Live Law and News Broadcasters Association approached Kerala High Court, company running the leaflet moved the Bombay High Court. The Delhi High Court was approached by digital news portals The Wire and The Quint and social media intermediary Facebook. And lastly, the Supreme Court has today reserved its judgment on the state of Kerala's plea for interim relief in its original suit challenging the Union of India's norms on borrowing limits, highlighting the state's unique financial landscape. The plea was heard by a bench of Justices Suryakant and K.V. Vishwanathan, which has been trying to find a solution to the state's urgent financial needs before the end of the current financial year, that is on 31st March. In defense of its overspending, the state has emphasized its substantial investments in critical sectors like health and education, factors contributing to its commendable human development indices. The union, on the other hand, stated that the state's revenue deficit indicated an unsustainable financial situation and that Kerala has consistently borrowed beyond their prescribed amounts in the recent past, further casting doubts about the state's macroeconomic stability. Over the last few weeks, the court has actively encouraged dialogue between the state and union governments to resolve this deadlock. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.